Okay, so we, I think, have a pretty good handle on speech and association, right? The last video was about freedom of association, and all the material we did before that on the First Amendment was about freedom of speech in the press, and prior restraints and speech forums and things like that. So it's time to move on to the religion clauses. And before we get into any cases, it's probably necessary to do a broad outline of how we're going to approach this. The First Amendment contains not one but two religion clauses. The first is the Establishment Clause. Lady, which prohibits the government from, well, what it says is that Congress may enact no law respecting an establishment of religion. Now recall again that it applies to the states through the 14th Amendment's Due Process Clause, the doctrine of selective incorporation. You see that doctrine coming back again and again as we talk about the First Amendment. So you can read that to mean any government, Federal, state, subdivision of a state is not allowed to establish religion. The question, of course, is what does that mean? Especially in relation to the other religion clause, Since there are two, clearly they can't mean the same thing. The other religion clause is the Free Exercise Clause, which I've done some writing about. It's a very interesting area of law right now, What does free exercise mean? You can think of it this way as to the two clauses and the way they relate. The Establishment Clause, courts have held, essentially instructs the government to stay out of the religion business itself, You're not supposed to start a government church. There's not supposed to be a Church of Florida or a Church of the United States, Those state associated churches have been bad news throughout the entire history of humankind. And so the idea there is that the government may not establish a church or pick a religion or promote a religion, or require that people follow a certain religion. Now, how far does that go is a question that courts still grapple with, How separate do church and state have to be for the government to say that it is not establishing religion? The principle underlying both of the clauses, the Establishment Clause and the Free Exercise Clause, is often referred to as neutrality. So I would know this language, Under the First Amendment Establishment Clause, the government is not allowed to pick religion over non-religion, non-religion over religion, because that would be religious establishment too, to pick atheism or agnosticism as the state religion. And it's also not allowed to pick one religion over any other religion. So the government is supposed to maintain neutrality and is not supposed to promote religion. It's not supposed to promote or inhibit religion. But can we be real for a second here? In modern political times, a lot of politicians usually do not get elected by running around saying there is no God, There's usually, the way this usually comes up in litigation, so I don't want to waste time here on stuff that doesn't really get litigated, is not an allegation that the government is, inhibiting the establishment of religion, but that the government is promoting it, And we're going to talk about three different fact patterns that arise, where that's the claim, where the government is promoting religion. So you can think of the Establishment Clause that way if it makes it easier. When you see a fact pattern where the allegation is that the government is promoting religion, that is likely an Establishment Clause question. Free exercise, so establishment means stay out of the religion business, don't promote religion, don't pick religion, that kind of thing. Free exercise tells the government to stay away from us as we practice our religion, So the Free Exercise Clause really stops the government from interfering with religious practices, with religiosity, religious belief, religious prayer, religious proselytizing, gathering, everything's up in the air now, but gathering for church services, sacraments, rites, rituals, all of the things that we associate with practicing religion, The government is not allowed to interfere with that. So if my allegation is that the government is promoting religion by spending money on, giving money to a church, that's an Establishment Clause, issue. If my claim is that the government is interfering with my religion by not letting me drink wine as part of my religious services, that is a free exercise. So I want you to keep thinking about that. If I'm alleging that the government's promoting religion, I got an Establishment Clause problem. If the government's messing around with people who are practicing their religion, that's a free exercise problem. So, once again, there, state neutrality, right? The government's supposed to stay out of it, is the basic principle. Okay, now those are the two religion clauses. First, you've got to figure out which clause you're under, right, as you go through a religion problem. We're going to start with the first one, the Establishment Clause, which is, again, the allegation that the government is doing something almost all the time to promote religion generally, or one religion in particular. Okay. The Establishment Clause cases break down into, and some commentators have gone beyond this, but I think for our purposes, this is fair to say. The Establishment Clause cases basically break down into three different types of fact patterns, right? So you got to figure out which type of fact pattern you're talking about, because that determines which test applies. And those, we'll go through each test in other videos, but again, this is just to outline where we're headed. In some cases, the allegation is that the government is promoting religion by giving aid to religious organizations or institutions. That can come in the form of money, or materials, or land, right? Anything like that, where the allegation is that the government, right, is siphoning off, right, some kind of help, right, financial, material, or otherwise, is giving something to religious organizations, and in that way is establishing religion or promoting religion. That's one kind of fact pattern as the garbage truck goes by. Isn't this fun? That's one kind of fact pattern that obviously would raise that issue, right? Is the government gone too far? Has the government gone too far in giving aid and material to religious organizations, where actually you can say at this point that the government is promoting that religion? So that gets one kind of a test. It's called the Lemon test, which has been modified. But we'll talk more about that. Why, with each one of the three fact patterns under the Establishment Clause, right, there's a different test, because the same test wouldn't be workable under each of the different types of fact patterns. Sometimes there's a little overlap. You know how lawyers handle that. If there's a little overlap, you think it fits a little bit into one fact pattern and a little bit into another. Lawyers don't panic about that. We just apply whatever we can from both. But you do want to first get this organized, right? There's these aid type of cases, right? Money and material going to religious institutions or organizations. That is one type of Establishment Clause case. The second category of cases we're going to talk about is when there is a display on public property, right, that is religious in nature. So I call these sometimes the Bah Humbug cases, because a lot of this comes up during the holidays. When there's some type of a religious display on public property, right, the allegation can be made that by putting up a religious display on public property, the government is promoting religion in general or a particular religion. And so that's another type of case. In those types of cases, courts apply what we call the Endorsement Test. So we'll be doing a video about that. That'll probably be a short one. The third type of fact pattern that can arise under the Establishment Clause is anything having to do with religious instruction, prayer, or anything else, and displays. So you can see a little bit of overlap there with the displays, right? The display type cases involving public schools, right? K through 12, right? You got to watch out for those. When it comes to something religious going on in public schools, courts tend to apply something called the coercion test. To repeat, okay, under the Establishment Clause, which is the first of the two clauses in the Constitution, you're looking for three separate types of fact patterns, right? The type of fact pattern presented tells you which test to apply. The first fact pattern, right, would be material or financial aid to religious organizations. That gets the Lemon test. The second would be a display, a religious display of some kind on public property. That gets the Endorsement test. And the third would be anything having to do with public schools, K through 12. Then you'd also have to look at coercion. Now, one of the things you'll notice as we run through the material is that there's one part of, right, all three tests that is identical. No matter which one of the tests you're applying, whether it is Lemon, whether it is endorsement, or whether it is coercion, you always look first, right? Basically the first element under any one of those is the government must be acting with a secular purpose. Now, do not confuse the words. I don't know why this stuff happens on exams, but I've seen the word sectarian used for secular. If you use the word sectarian when you mean secular, not only is that the wrong word, it means actually the opposite, right, of the word you were looking for. Secular means non-religious, right? It doesn't mean anti-religious. You see that a lot in some of the political debate that goes on, right? Secular means anti-religious. Secular does not mean anti-religious. It means non-religious. It means not concerned with religion. Under this principle of neutrality, under the Establishment Clause, courts always look to whether the government is acting with a secular purpose, right? If the government is not acting with a secular purpose, in other words, if it is acting with the purpose, right, of promoting or inhibiting religion, you're finished. That's the end of the case, right? No matter what test you're applying, you always look first to what is the purpose, right, underlying whatever government action is being challenged. Be careful with this. You're used to the strict scrutiny cases where courts will kind of, with a wave of the arm, say, yeah, whatever, we'll buy whatever you give us as your purpose, and then strike it down on some other grounds. In these religion cases, sometimes the courts are deferential to the government. That's a word, again, you got to know, deferential. Sometimes courts say, all right, whatever you say, we'll believe it. Other times, not so much. For example, when you tell a judge who probably is a religious person himself or herself that the Ten Commandments is not religious in nature, right? That there's some kind of secular reason for posting the Ten Commandments, sometimes you'll provoke a court into calling that a sham, right? So what I'm saying is be careful with the secular purpose, right? Take a minute to look at that. Take a minute to look at the fact pattern and see if there's anything going on there that looks like if the government's going to make some excuse to say it was really just trying to promote the public welfare or public education or something like that. But there's something in the fact pattern to indicate, right, that that's not what was going on. I'll talk just about one case very briefly, right? The case in your book, from your reading, where a member of the state legislature, I believe it was state senate, actually admitted in court, right, that the reason for getting a moment of reflection or silence, right, back into the school curriculum, that person actually admitted, first of all, on the floor of the Senate, right, of the state legislature, and then in court. I believe his exact quote, and this is pretty bad sloppy language, but when asked, was there any other purpose for the law except to reintroduce prayer into schools, he said, no, there was no other purpose, right? Okay, so look, if you got those facts in your fact pattern, we don't get past secular purpose, right? If you're acting with the purpose to inhibit or promote religion, okay, in an Establishment Clause case, the case is over. All right, so that's a brief introduction to the outline of the religion clauses, and particularly where we're going in the next few videos, right? One video on lemon, one video on endorsement, and one video on coercion. And again, those shouldn't be long, but you put those all together, and where there's overlap, you look at whatever you can. So we'll be back later with another video. Next one will be on lemon.